morning and welcome to the Burr Broadcast, where we provide you with important legal updates on the latest labor and employment news. My name is Gabriell Jeffreys and I'm an associate in Burr & Forman's Birmingham office. Today we're going to discuss the EEOC's proposed rule to implement the Pregnant Workers Fairness Act. So, as many of you may know, the Pregnant Workers Fairness Act went into effect a couple months ago on June 27, 2023. And this law requires employers to provide reasonable accommodations to a worker's known limitations related to pregnancy, childbirth, or related medical conditions. That is, unless the accommodation would cause the employer an undue hardship. So after that law went into effect earlier this week on August 7th, 2023, the EEOC issued proposed rules implementing the Pregnant Workers Fairness Act. These rules addressed each element of the accommodation requirement and provided some example scenarios. So I want to go over some of the key terms we've gotten from this rule. One of the major things that it did is provided some clarification on how the EEOC plans to interpret several key terms in the statute. It gave some examples of what qualifies under pregnancy, childbirth, or related medical condition. So this doesn't just include current pregnancy, it also includes past pregnancy, potential pregnancy, and other pregnancy-related conditions such as lactation, including breastfeeding and pumping, the use of birth control, menstruation, infertility, fertility treatments, endometriosis, miscarriage, stillbirth, or having or choosing not to have an abortion, among other conditions. It also gave us some clarification on what is required to request a reasonable accommodation under the Pregnant Workers Fairness Act. It told us that the employee or applicant need only communicate to the covered entity that the employer applicant has a limitation related to pregnancy, childbirth, or related medical condition, and that they need an adjustment or change at work. So in addition to giving us this definition for what you have to do to request a reasonable accommodation, the proposed rule also gave us some real life examples of what that looks like. So one of the first examples it gave is that a pregnant employee tells her supervisor, "I'm having trouble getting to work at my scheduled starting time because of morning sickness." This was an example that the EEOC said would qualify as a request for a reasonable accommodation under the Pregnant Workers Fairness Act. So in addition to giving us a definition of what qualifies as pregnancy, childbirth, or related medical condition, and also providing some instruction on what it takes to request a reasonable accommodation, the proposed rule also outlines some potential reasonable accommodations. These include frequent breaks, allowing for seating in jobs that require standing or standing in jobs that require sitting, schedule changes, part-time work, leave, telework, parking, light duty, modifying the work environment, job restructuring, temporarily suspending one or more essential functions of the job, and modifying equipment or uniforms. So those were just some examples that it gave, and these are some of the key points this proposed rule provided. But it is important to remember that at this time, these are only proposed rules, which are not yet final. The EEOC will be soliciting comments from the public on these rules for 60 days from the date of publication in the Federal Register. The EEOC then has until December 29th, 2023 to issue final regulations to implement the law. If you have any questions regarding these topics, please do not hesitate to reach out to Burr & Forman's Labor and Employment Group. Our team is always prepared to help you navigate these issues. Visit us today at www.burr.com.